And a pleasure to welcome into our studios Nancy Ling. We're going to talk about probate fees and the concept of multiple wills to participate in probate planning. But if I quickly go to the concept of probate, Nancy Ling, what is it about that word probate? What is it about us that we're always trying to sidestep and avoid probate fees? What is it about us that somehow we feel that this is the burr under the saddle, if there's anything? Good morning to you. Sorry.
Good morning.
Good morning.
So probate is a process where if you have a will and it needs to be verified by the court, and that's going to depend on third parties. Not all wills need to be probated. If a person dies owning real estate in their sole name, depending on the amounts in bank accounts, the land title office and the banks are going to require that will to be verified to make sure that it's the most recent will and it's valid, et cetera. So that's probate. And probate fees are paid when you have to probate a will, and they're essentially percentage-based. So what they are is on under $25,000, there's no fee. For the value between $25,000 and $50,000, it's $6 on every $1,000, rounded up, so approximately 0.6%. And then for everything above $50,000, it's $14 for every $1,000, so approximately 1.4%. So a good rule of thumb is for every $1 million, you're paying $14,000 in probate fees.
Stupid me, that doesn't seem onerous. It seems that it would be logical to pay whatever court clerks or whatever clerks have to research through documents, whoever has to poke their nose in to make sure that the stamp that is on there certifies and is authentic and so on and so forth. It would seem to me to make logical sense to certify that this will is the real McCoy, the real deal.
Right. But, I mean, sometimes people want to avoid this unnecessary tax if they don't have to go through the probate process. Also, when you probate a will, it's now public. So some people want to keep their will and things private. So there's a couple of reasons that people will try to avoid the probate process and thereby the probate fee. But like you're saying, it's not an overly onerous tax or fee. So sometimes the steps people take to avoid probate fees will land them in the hot water with income tax issues, or maybe they've done some planning that just wasn't wise. So one of the ways that people try to get around probate fees is gifting things while they're alive or putting their children on joint tenancy with their house. And those can have unintended or disastrous results depending on the family. So if you gift too much during your life and you run out of money, or you put a child on title and all of a sudden your child's creditors lean against your house. So
there's all kinds of horror stories.
Right. So, I mean, there are good reasons to do some probate fee planning, but you want to make sure that you're not stepping, out of the kettle into the fire to save a couple $1,000s and end up in worse trouble. So it's a good idea to look at the options and make sure you look at the pros and the cons and that it's the right plan.
I know of a family that gave gifts regularly to children and grandchildren. Generally, every year at about this time, there was a gift basket, and tucked inside was cash money to a certain size, depending on your position within the family, kind of thing. But what was interesting is that each of those kids had to sign to say that they had received the money. Because the parent wanted to be sure that there was a record kept, that this was a gift that was given.
Right. Well, one of the things that happens with gifts is you're still open. A will is still open for these variation proceedings after someone dies. So if you give one child a whole bunch of money and you don't give the other child, et cetera, they might bring that up after you're gone and start talking about whether this was a gift or whether it was a loan, et cetera. So always it's a good idea to document your true intention.
So there was a lawyer somewhere that said, okay, Ralph, if you want to give this money, that's fine, but make sure that each of the kids sign on the dotted line after the Christmas wrappings have been put away and the turkey has been carved. Make sure that somebody signs on the bottom line so that they understand what it was they've received and that they're totally happy with it.
Yeah, and there's some record when you're no longer around to give your own account of affairs.
Right. I know some people who thought that was a little cold-hearted. Somehow it just didn't seem to fit within the generosity of Christmas, and yet other people who were a little more practical said, you know what, this makes all the sense in the world.
It's not a bad idea to have an open dialogue with your family about what you're doing when you're doing these sorts of things, because once you're gone, you don't want everyone to have bottled everything up and it all comes out when they're grieving and then they're fighting.
No kidding. Absolutely. Nancy Ling is in our studios this morning. We're talking about probate fees, which indirectly is a tax, if you want to think about it, on the processing of a will and the value of that will. But the whole concept of multiple wills is what we're going to talk about in a moment. Quick break here, then we'll come back with Nancy Ling. Multiple wills, why? What does it do? How does it protect you? Or is it just excess and extra paperwork that benefit those who put stamps on the bottoms of things? Back with Nancy Ling in a moment. Nancy Ling is in our studios from FH&P at 275 Lawrence, talking about probate fees and the concept of using multiple wills for probate planning. But first of all, Nancy, if I could, I'm just looking at something here that deals with the difference between probatable assets and non-probatable assets. What's the delineation between the two?
So in order to understand probate, you have to understand how assets move when you die and what you end up owning and don't own when you die. So there's certain ways that assets can pass outside of your will, outside of your estate, like if you've got a designated beneficiary on an account, again, things owned in joint tenancies, assets that are owned in a trust, an alter ego trust, etc. Those go separately outside of your estate. Then what's in your estate, whether it requires probate, whether it's probatable, again, depends on these outside third parties. So land title office, anytime you own real estate in your name alone and you die owning that real estate, that is a probatable asset. You cannot transfer land without the will being probated. And bank accounts with large sums of money in it. Every bank is unique on what their policy is with requiring probate. So what amount will have to be in that account? Maybe it's $50,000. That's a probatable asset. Non-probatable asset is going to be your household effects. You know, nobody needs proof to take the couch, the dining room set, whatever. And the other big thing, which is why multiple wills are such an important tool right now, is corporate assets, shares in a closely held private corporation. So if you have a holding company with your wife or a partner, a business partner, those shares don't need probate unless the directors of the company require it. So if you and your partner of 30 years have run a tile business or whatever, and that company is worth millions of dollars, your shares are worth millions of dollars, you don't have to pay probate on that fee on those shares unless the directors require it, which usually they wouldn't. So that's why multiple wills comes in. If you have these corporate assets pass through a different will, it doesn't need to be probated. And then you put your real estate and your large bank accounts in your name alone under the probate will. Those items do need probate. So you separate out the assets that do need probate from the assets that don't need probate. And therefore, depending on the value of things, you can save quite a bit of probate fees.
Now I understand why people try so hard. If I'm getting anything from you, if I'm hearing anything from you, really is that if you have significant resources, significant assets, and there's some serious money here, absolutely, you need to pay very close attention to try to save probate fees. But let's face it, if you've got $15,000 in an account here and you've got a piddling amount over here and you might have a few shares in General Motors and the Ford Motor Company over there, you really don't need to spend a whole lot of time and energy trying to avoid these fees.
Right. And almost all estate planning is a discussion about what your intent is, what tools there are at your disposal, and a cost-benefit analysis, right? It would be great if everyone could set up a trust and avoid all kinds of attacks under wills variation and taxes, et cetera. But at the end of the day, it's so expensive to set these up and the taxes on them that it may not be worth setting up a trust. At the end of the day, it might not be worth spending the money to do two wills.
Talk to me about the process of setting up a trust, a testamentary trust?
No, I was more talking about an alter ego trust,
okay.
An inter vivos during your lifetime trust.
Take us there.
Okay. So there is a trust that is a creation of the Income Tax Act these days. It's called an alter ego trust or a joint spousal trust, where during your lifetime, you can put your assets into a trust where you are the beneficiary or you and your spouse are the beneficiary during your lifetime. And after that, you can say who the remainder beneficiaries are. So that's not going to go through your will. That trust is a separate entity. and it will be governed by the document, what you say, what you want to happen to those assets that are in it. Whereas the assets that you own personally will be governed by what you say in your will. So again, it's a way of separating out things that will go into your will and what won't. And some people use that to defend against a potential variation claim for distribution of their estate. Some people use it for tax planning. And it's also a good planning tool for potential incapacity, because you can have an alternate trustee to start taking over running your assets if you lose capacity.
Right, a stroke or whatever, where your brain capacity is diminished, and now you need somebody else to administer your affairs.
Right. All
right. And does any of that reflect back? I'm unfortunately sort of referring to a personal family situation, and I need to be careful where I go here. But if certain provisions are written in, and I'll just say the word, my mother's will, if certain provisions are in there, a lawyer has suggested to my mother that there need to be certain provisions made for a black sheep brother, for lack of a better way of expressing it. There is definitely a black sheep in the family. And the lawyer is very concerned that if certain things don't happen, the black sheep side of the family could decide to challenge the will and put everything through a very long and protracted legal circumstance.
Right. Unfortunately, the law in BC is that any child and any spouse has the right to contest the provisions made in a will.
Right.
It could even be a 50-50 split between siblings, and one sibling still has the right to contest that, to say that, it's not fair, I deserve more, I, took care of mom when she was ill, that sort of thing. So there's nothing that you can do. It's a right under BC law. There's nothing you can do to stop someone from challenging a will. What you can try to do is stop them from being successful. And what you can do is to try and put up certain protective measures. So a lot of times we do planning for a beneficiary that might have money problems, that might have addiction problems, that might have, an abusive spouse, something like that. So you don't want to put the money directly into their hands. You can set up a testamentary trust in the will where that money isn't going to go directly to them. It's going to be taken care of by their sibling or whoever for them during their lifetime.
Going to be administered on their behalf.
Right. And you make sure that there's someone behind them in line so they aren't absolutely entitled to that money. So you do a gift over to, grandchildren that don't exist yet, or the other sibling, etc.
What if you don't have someone in line?
You need to. There's a rule that if you set up a trust for someone and they were the ultimate beneficiary and they're over 19 years old and they have mental capacity, they can make an application to collapse that trust because it's essentially theirs. Whereas if you put someone behind them in line, then it's not essentially theirs. It's theirs for the time being.
Can you put the public trustee in place to manage that? And I'm sorry, I'm blindsiding you here, and I apologize for that.
No, you can try. I mean, the public guardian and trustee is a public appointee. They have public resources, which, as we all know, are not unlimited.
Yeah.
So they're going to take the really needy cases, the cases where there's absolutely no one else, and the cases where these individuals are at risk, because they're in charge of anybody under a legal or mental disability. So minors and people with mental disabilities. So just because you've got a, black sheep sibling that nobody really wants to look after, but there's people there that could,
right,
doesn't necessarily mean that the public guardian trustee will step in if there's other people that could.
All right. Okay. One quick break, then we'll come back with a couple more quick questions with Nancy Ling from FH&P. This is our Tuesday morning law talk, talking about wills, probate, and multiple wills to help you through a very complex process. Back in a moment. Nancy Ling from FH&P in our studios this morning. We've been talking about wills, probate, multiple wills to assist in probate planning. But Nancy, if there's anything that I wanted to just touch on before we said thank you for this day, it is the fact that too many people, or so many people, in the minds of I do know that Jim at times is concerned about people making gifts, giving too much away, and then finding that at some point in time, as their retirement lasted longer or medical emergency arose or whatever, they suddenly don't have the resources to deal with it, and you've got to be careful of that.
Yeah, I'm often coming across this mindset where, I have to give my kid this money because I gave my other kid that money. And I'm saying, no, you don't have to give anybody any money. So it is worth a very careful look at your budget and your plan before making any gifts. And it's important to remember that you have no idea what's coming down the road. You might end up having some illness or medical condition where you have to spend quite a bit of money either to adapt your home if you want to stay in your home or hire nurses or whatever. So you don't know whether or not you're going to need those funds. And so, yeah, it is important to give that consideration before you give away money. Once you give it away, you can't get it back.
What's that saying? If I'd have known I was going to live this long, I probably would have looked after myself better than I did, kind of thing.
Yeah.
Because I think increasingly with the advent of better medical care, chemicals, the magic that chemicals work within the human physiology is absolutely unbelievable. And suddenly you're living way, way beyond where you thought you were going to be.
And not to be cynical, but just because you supported and cared for your children doesn't necessarily mean that that's going to be reciprocated in your dotage.
Isn't that the truth? So. Yeah. Could you say that again?
Not to be too cynical, but you can't necessarily count on your children to support you financially and to care for you if you need it.
Do you see this in your practice?
I do, yeah.
Yeah. Does it dishearten you?
Yeah, sometimes. But I see the opposite as well. I see kids that devote a great amount of their time and a lot of their resources to caring for their parents, unfortunately.
And then the parent doesn't reciprocate in the way that the kid thought that they should.
Right. That happens as well.
Yeah. Yeah. But I looked after you all these days. I changed your depends. Yep. I fed you. I scooped the pablum off your chin. You owe me, you old SOB. Did I correctly typify that? Or
there's no
give
guarantee.
Character to
There's no guarantee when you're dealing with human beings.
The only guarantees are death and taxes.
Yeah, there you go.
And a good lawyer to help you through it.
Here's hoping.
Nancy Ling, always a pleasure. Thank you for being in our studios. If you'd like to reach her, her direct line is 448-0527. I'll do that again, 448-0527. Better, however, to go to the website, to FH&P Lawyers, and go down the roster of the lawyers who are there. Nancy Ling's page will be there, and that is the best way for you to connect directly with her. Nice to have you in the studios. I don't know if we'll see you before Christmas, so to you and all the folks over there at FH&P, best of the season.
Thank you.
Thank you so much.